Mhm. Good afternoon, everyone. We're just gonna give it about a minute or two as I can see all the participants coming in, so sit tight. Another minute or so, Pam. Still a bunch of people coming
Sure.
in. Yep. All right. What do you say, Pam? Should we get started?
Let's get started and people can join when they're ready.
Excellent. All right, good afternoon, everyone. Thank you for joining us today. Your host today, or panelists, are myself, Matt Gaines, and I'm joined by Pam Jonah. We're both partners here at Marcus Arrico, Emmer & Brooks, and we, for better or for worse, have sort of been deemed the kind of experts in our office on all things reasonable modifications and reasonable modifications. And we put on this presentation a bunch of times and we're always updating it. And this time there's some new information in here, particularly when it comes to reasonable modifications and some changes based upon a recent court case. We're going to, start with a kind of general overview of the law, and then we'll get into some specific, situations of both modifications and accommodations. There is the Q&A function within Zoom. We would ask that you use that and to type your questions into that. We are going to wait until the end to answer any questions, because it is quite likely that we'll probably answer your question, or at least come close to answering your question in our presentation. And we've got quite a bit of material we want to cover, and we do try to limit it to an hour or so. So with that being said, Pam, why don't you kick us off?
Good afternoon, everybody. I just want to preface this by saying, and Matt referred to it, but the first several slides that I'm going to be speaking about are more or less to give you a background on the area of law that is applicable when residents ask for reasonable accommodations and modifications. So while I might mention a few examples, I'm not going to deep dive into them until later on in the presentation. I think it's important for everyone to have a general knowledge of why these laws are put in place. And essentially, they're put in place in order to ensure that disabled individuals are given equal access to housing. So oftentimes I find that boards and property managers may think like, well, why did they move into this particular condominium to begin with, when they knew that we didn't have wheelchair ramps, or we didn't have this, or we didn't allow pets? And the reason and the reason why they can do that is because the federal and state law both say that any individual, even an individual with a disability, has to be given the opportunity to live where they want. They shouldn't be precluded from living or enjoying in this case, their unit, just based upon the fact that they have a disability. So getting to the two areas of law that apply in Massachusetts. So there's the federal law, which is the Federal Fair Housing Act, and we gave you the citation on the screen. I can tell you that is an incredibly burdensome article to read, and probably nobody's going to want to actually look up the Federal Fair Housing Law and read it. Luckily, the U.S. Department of Housing and Urban Development and the Department of Justice have both over the years released either notices or bulletins, or a few years ago, they actually released a set of regulations that basically tell you their interpretation of what the law requires relative to housing. Then there's a state law in Massachusetts, Mass General Law 151B, and that essentially also basically says the same types of things that the Federal Fair Housing Law says in terms of what's required. And then the case that I'm going to speak about later is actually interpreting that state law differently than it has been interpreted in the past. And that's going to give you some updated information. But basically, both the federal and state law prohibit discrimination in housing based on race, color, religion, national origin, sex, gender, identity, sexual orientation, age, marital status, family status, and relative to today's discussion, disabilities. One other thing about the law, oftentimes the people that make the request for accommodations will confuse which law applies. When it comes to housing, it is not the ADA law. The law, again, as I already mentioned, is the Federal Fair Housing Law and the state law that's referenced on your screen. Next slide. So again, what actually constitutes discrimination against individuals with disability when it comes to housing? A refusal to make a reasonable accommodation, i.e. an exception or waiver to the restrictions, rules, and policies or procedures when somebody asks for an accommodation and indicates that they have a disability that prohibits them from enjoying the use and enjoyment of their unit or common areas based on that disability if they are not granted an accommodation. The second prong is a refusal to permit reasonable modifications, physical changes to the common area of the condominium, if such modification is necessary to afford a disabled person full enjoyment of the premises. So it's two different things. Sometimes the request will come in and it's that they're looking for an exception to a rule. So the easiest one, and the one that everybody's most likely familiar with, is it's a no pet community. A person moves in with a dog and they say it's an assistance animal, and now they want to keep the dog. They want an exception to the rule prohibiting pets. The second prong, which is a different thing, it's a reasonable modification, probably most likely self-explanatory based on the definition on the screen, but that is a request to make modifications to the common areas such as wheelchair ramps, chair lifts in the halls, and things like that. We'll give examples later on of the various types of requests and explain the process later on. Next slide. Let's see, request for reasonable accommodation / modifications. So in order to qualify for the requested reasonable accommodation or modification, the individual making the request must demonstrate primarily demonstrate two things, two criteria. First, they have to demonstrate that he or she meets the definition of a disabled person according to the law. Second, they have to establish that there's a nexus between their particular disability and the requested accommodation or modification that they are seeking, i.e., how will the requested accommodation or modification allow the disabled individual to enjoy the housing? So in all instances, when an individual is requesting either an accommodation, a waiver of a rule, or a modification to the common areas, they have to meet the two criteria. That does not mean that you yourself should be saying, hey, what's your disability? The law does not permit a board or a property manager or really anybody in a housing context from saying to the individual, well, what's your disability? Matt will get into later on exactly what you are able to ask, but essentially you should never ask that question. That is already a discriminatory action. Next slide. So this is just the definition of the disability under the law pursuant to the Federal Fair Housing Act and pursuant to Mass General Law. A disability is a physical or mental impairment that substantially limits one or more of the major life activities of an individual. It can also be a record of having such an impairment. And I view that as, briefly, this can be shown through a letter or form provided by a medical professional if needed, but we'll go more in depth into that later on. Being regarded as having such an impairment, I would say that an example of that would be, it's an open and obvious disability. Somebody's deaf, somebody's blind, or it could be something as simple as a resident has a handicap placard. If a resident has a handicap placard, then just by virtue of the fact that they have that, it's been produced by the state. Therefore, you can assume that they have a disability. Next slide. Obviously, we've mentioned that there's two types of disabilities. There's the physical disability, and there's some examples on the screen of that. Those typically will suggest that the person is seeking a modification of the property, but it could also be an accommodation situation in terms of maybe where that person is permitted to park on site. Then the mental impairments, and there's a full list: the depression, the anxiety, panic disorders, PTS, obsessive compulsive disorders. That's the gambit of them. And I would say that those typically come into play when people are seeking to have an accommodation in a no pet or limited pet condominium, and they say that they need an assistance animal, either an emotional support animal or a service animal. Next slide. Major life activities. If you recall, the disability definition is that somehow they have an impairment that limits their use and enjoyment in major life activities. So caring for oneself, performing manual tasks, seeing, hearing, eating, walking, standing, all of the things that people do in their daily life that a disability could potentially affect, and therefore that is the reason that they are seeking either an accommodation or a modification. Now that we've covered the law in general, Matt will discuss the actual process for responding to such requests and the do's and don'ts regarding same, and then both of us will get into some future examples.
Thanks, Pam. So if you're a board or a board member or a property manager, what do you do when you actually get one of these requests for an accommodation or a modification? So the first thing to keep in mind is that, and it's a little bit of a misconception, is that the request does not have to be in writing. It can be made verbally. So, an owner could, be speaking on the phone to the board or property manager, or show up at a meeting and make the request that way. It doesn't have to be in writing, and they're not required to use, the magic words of reasonable accommodation or reasonable modification. They could just say, hey, I have a disability and I need a wheelchair ramp, or I need a dog, whatever it might be. They don't have to use those magic words. So sometimes, you have to, read through those words, and better safe than end up in a bad situation. So if you think that someone has a disability and that's why they're making the request, you always go with the presumption that it is that type of request, and kind of get your guard up and handle it accordingly. Next thing, an important takeaway, as you can see, because I put it in bold and underlined, is don't deny. You cannot be accused of discrimination, and you can't necessarily find yourself before the Mass Commission Against Discrimination until you've actually denied a request. Obviously, at some point, you have to make a final decision. You just can't keep kicking the can down the road. But, when you first get the request, your initial response shouldn't be, no, we have to discuss. It should be, we have to discuss, or we need more information. Do not deny that request, because again, there's no discrimination until their request has actually been denied. And somewhat related to that is the next thing that I've bold underlined with 3 exclamation points to really drive home the point, is engage in an interactive process. And those words, interactive process, actually come straight out of the Mass Commission Against Discrimination in various cases. They love to see that. In the event that you end up denying a request and you find yourself before the Mass Commission Against Discrimination, there is nothing that makes our life easier at defending you in that case than if we can show to the MCAD that you tried to work with this, this resident, and that you engaged in this interactive process. You asked for information and they didn't provide it, or they asked for information and what they provided you wasn't sufficient. Whatever it is, there's that back and forth, and you can show that you tried to work with them. That is critical to these situations, particularly if you do end up denying the request. You have to provide a prompt response. You can't just sit on your hands and wait to respond. And in fact, an undue delay in responding can be deemed a failure in and of itself to provide the accommodation, and can be a form of discrimination itself. The biggest mistake that I see boards make is they get the request in, and they say, okay, our next board meeting, say they get the request on May 15th. And they say, okay, well, the board's meeting again on June 15th, or maybe not even until July or something like that. And we'll discuss it then. No, we are in an age today where you can discuss things over email. You can quickly set up a conference call, a Zoom call. The MCAD obviously knows all those things exist. There is no reason to delay at least having the initial discussion for 30 days. And in fact, I think there's even some guidance from the Department of Housing and Urban Development that indicates that 10 to 14 days is a reasonable time to respond. Now, that doesn't mean you have to give them the final answer within 10 to 14 days, but at least within that 10 to 14 days, you should say, okay, thank you. We got your request. We need some more information, or we got your request and, the board is going to meet, next week, not 30 days from now, but, something like that. At least let them know that you received it and it's being reviewed. The worst thing you can do is just say nothing, and they think it's just gone into a black hole and nothing's happening. I've seen a lot of boards and managers do that, and that never really ends well. And then finally, obviously, and I'll talk about all the paperwork you can ask for, but eventually, if you get all your paperwork in and everything looks good, or maybe it doesn't, eventually you have to make a decision, and you either approve it or you deny it. If you approve it, you may be able to impose some conditions on it, and we'll talk about that when we get into some of the specific situations. Or obviously, if you were to deny the request, again, make darn sure that you've got a legitimate reason why you denied that request. So just a little bit more on the interactive process that I talked about. Again, that this is really critical, and what does that mean? Engaging with the resident in a discussion. Number one, make sure that you're clear on exactly what they're asking for. Particularly if the request comes in verbally as opposed to writing. Sometimes, I suggest that, the board follow up with an email or a letter to the owner saying, hey, you mentioned to us that you want this. We're just confirming, is this exactly what you want? Maybe it pertains to like a wheelchair ramp. Okay, where do they want it? Do they want it at the front door, the side door, the rear door? Make sure you get that request, in, clarifying what they want. Or if it's dogs, I've had some people that ask for 2 dogs, just getting that confirmation. Are you asking for 1 dog or 2 dogs? What exactly is it that you're asking? Make sure all parties are on the same page there. The next step is that, what information, if any, must the resident provide to verify the disability? And I'm going to talk about that a little bit more, but that's kind of, again, part of the interactive process. And what information do they have to provide to establish the nexus or relationship between the disability and the request? How will the request help the disability? And obviously, the last part of the interactive process is discussing alternatives. Again, when it comes to pets, that's usually not an option, but there can be other situations where alternatives may apply. Again, the wheelchair ramp. They want it at this door. It's not feasible, or it wouldn't really be practicable at that door. Is it possible to have it over here at this door instead? Discussing those types of alternatives with the owners. How do you establish the disability? That's kind of the next step in the process. Once you confirm with them what they're asking, so you're on the same page, the next step is, okay, well, is this person even disabled? Because you're only obligated to provide accommodations and modifications if the person is actually disabled. So a disability can be established by if it's an open and obvious disability. Again, if somebody's in a wheelchair, that's an obvious and open disability. You don't ask for any paperwork in that situation. Similarly, if somebody is, blind and has a seeing eye dog, that's open and obvious. When it's not open and obvious, tends to be more some of those mental impairments that Pam was talking about, stress, depression, anxiety, PTSD, and those all go to the emotional support animals. If a disability is open and obvious, as I just mentioned, you cannot ask for any documentation, certifying that. So again, if someone's in a wheelchair, someone's blind, you can't say, hey, get us a doctor's letter stating that you're disabled. Their disability is obvious. Similarly, if the need for the accommodation or modification itself is evident, you can't ask for that nexus. So again, someone, I keep harping on it, but someone's in a wheelchair and they said they want a wheelchair ramp. Okay, their disability is obvious and their need for it is obvious. At that point, there's no doctor's letter is necessary. But in some situations, and again, this mostly pertains to mental impairments as it relates to, the emotional support animals, the disability is not obvious. You can't tell by looking at someone that they have stress, depression, PTSD, whatever it might be. And in that case, the board is entitled to request and receive documentation from a qualified professional that, and this is really it, these three bullets, that A, the professional certifies that the person meets the statutory definition of a disabled person. Pam touched upon that earlier. It's someone who has a physical and mental impairment that substantially limits one or more major life activities. Number two, the doctor describes the accommodation or the modification and says, okay, my patient is requesting a dog. My patient is requesting a wheelchair ramp. My patient's requesting, grab bar, whatever it might be. And finally, you demonstrate that nexus, that relationship. How will this accommodation, how will this modification, help the resident equally enjoy the premises? So again, kind of playing those three things out. I certify that my patient is disabled under the meaning of the statute. They're requesting an accommodation to have a dog. The dog is necessary because it will alleviate their depression, their anxiety, whatever it might be. So that's a typical, letter that you might see. As for who qualifies as that qualified professional, it really can be sort of anybody who has knowledge of the person. It can be obviously a doctor, but it could also be a social worker, a therapist, a psychologist, a psychiatrist, somebody who is, is familiar with the resident's circumstances and is qualified to certify to those three bullet points above. Important reminder, obviously all medical information should be kept private, really just for the board and property managers and your attorney's eyes only, not to be shared or kept in any files that could be shared with all the other residents of the building. And also, the applicant doesn't have to really reveal the specific nature or severity of their disability. It's enough that the professional says, my patient is disabled and they need this. They don't have to go into the great detail of all their medical history and conditions. What are the circumstances under which you could deny a request? So the number one is that the individual does not qualify, meaning they're not disabled. I've had that come up. Not in many cases in my 16 plus years of doing this, but a handful of times I got a letter from, the doctor that says, my patient has a medical condition and I recommend that they have this dog. Well, all medical conditions do not rise to the level of a disability, and a recommendation that they have a dog is different than the dog is necessary for them to equally enjoy the housing. So when I see a letter like that, I push back and I say, well, this letter is not really clear. If you are disabled, not all conditions rise to the level of a disability. Therefore, we need additional information. And on a couple occasions, I've actually had the doctor or therapist respond and say, no, actually, their condition does not rise to the level of a disability. They only have, mild depression or mild anxiety, which who of us doesn't have a little depression, anxiety, and stress in our lives? And so if that's the case, then they're not disabled and you can deny the request. Another example would be if the accommodation would cause a direct threat and somehow that, and we can talk about that a little bit more when it comes to, pit bulls and things like that. But, you really have to know specific situations and not just kind of stereotypes or generalizations that would be a direct threat to other residents in the building. You could deny in that situation. And then finally, if the request is not reasonable, and this third bullet goes more to the modification side of it than the accommodation, in that the request is not reasonable if it would pose an undue hardship upon the association. And that includes, the nature of it, whether it's physically impossible for the modification to be installed, or the cost. And actually, the cost issue is not going to be so much of an issue anymore under this new case that Pam's going to talk about. But in terms of the first one about, physically impossible, I'll just give you a quick example of a case I had a number of years ago where you had a building that was set back a bit from the parking lot. It was slightly elevated with a slope. And there was, a long walkway down to the parking lot. And then once you got there, there was about 4 steps to actually get down into the parking lot. A woman who was disabled, she wasn't in a wheelchair, but very clearly had mobility impairments. I think she used either a walker or a cane, I can't remember. And she wanted a ramp for those 4 steps. So when she got out of her car, she couldn't navigate the steps. She could go up the ramp and then go up the long walkway and really not have any other steps. However, the way the parking lot was situated was that you had the steps, and then immediately to the left and immediately to the right were parking spaces that were, deeded easements for other residents. And typically when you put these ramps in, or not typically, but they have to be into code, and depending on how steep it is, you might have to zigzag a little left and a little right, so it's not too steep of a drop. Well, the only way to put that ramp in was essentially would have taken away space, the parking space to the left or the right or both. Or if you made it one long ramp, it would have gone out literally into the middle of the parking lot, which obviously is dangerous and would have impacted snow plowing. So we denied the request and say it's just physically not possible to put this ramp where you want it. She filed the claim with the Mass Commission Against Discrimination, and the MCAD actually asked for a site visit. And we all met out at the site one day, including the investigator from the MCAD, and we were there for about 5 minutes. And the investigator says, yeah, I don't see how it's possible to put this ramp in. So the case was dismissed and we prevailed. So, those situations don't come up often, but there can be a situation where it may not just be physically possible to install the ramp. So that's kind of a lot of the background about, what you do when you get the request. Now we're going to get into some specifics about modifications and accommodations, and Pam will kick it off on this.
Okay, so again, this slide isn't going to be very specific, but I'm just going to give you some examples. They're probably somewhat obvious now, but there's the 2 types. There's the modification. The common ones that you're probably familiar with are requests for wheelchair ramps, stairway chair lifts, possibly automatic door openers. I've even seen requests for flashing lights in the hallways, because the unit owners are deaf and they're not going to hear if there's a fire alarm. I've heard for requests for modifications to the buzzer that lets people in, because the unit owners are deaf. So those other somewhat modifications. Then there's the request for accommodations, which are a waiver of an existing rule or restriction. And typical ones that we see are designated handicap parking spaces, unit owners saying that their current space is too far away from the entry, they're handicapped, and they want to have a space closer to the entrances to the building. Another popular one is the use of a generator. Oftentimes, condominiums will say, no generators because of the noise factor, maybe because it's it could be considered somewhat of a danger to the association, but depending upon location. But those will typically come up when people have conditions that affect their breathing, or they may be elderly and they can't withstand extreme temperatures. So primarily, like I find, they come up in the summertime when power might go out, or somebody might be actually on some sort of medical device that needs electricity. So they'll ask for an accommodation to allow the installation of a generator if the power goes out. And the ever so popular request for assistance animals, which Matt is going to deep dive into later on in the presentation. Next slide. Okay, so here's the exciting portion of my particular part of the presentation, I think. There's been a recent case that is actually benefiting the association, the boards, and the property managers to some extent. So it's the case came out a few months ago, and ultimately what it does is it changes who has to pay for the reasonable accommodate or the reasonable modification to the common areas. And the case is indicated on the slide, Gizzle v. White Cliffs Condominium 4 Association. And I would preface that by saying that prior to that case, we always gave our advice based on what a case that the Massachusetts Commission Against Discrimination, otherwise known as the MCAD, they had a case where they interpreted what the state statute requires in terms of who pays for the reasonable modification to the common areas once it's determined that the resident or individual requesting it requires it. So it was actually somewhat exciting when we saw this case come across our radar. In that particular case, an owner wanted to modify her patio due to mobility issues. The existing patio was in what's called limited common area, but they wanted to make a modification to it. The association at a lower level, when it was in an agency because basically the association said, no, I'm not going to allow you to modify the patio. And if we do allow you, it's going to be at your cost. So she didn't like that response. So she, put in a complaint with HUD, I believe it was. And essentially, while that was happening, at some time during the process, the pendency of a complaint, whether it's before HUD or the Massachusetts Commission Against Discrimination, an owner has the opportunity to take that out of the agency and put it into court. Also, at some time in the process, the defendant, I'll call them the defendant, although they're called the respondent in the agency, which would be either the board or property manager or both, they often have an opportunity at a certain portion of the juncture in the in these agencies to also remove it to court. So ultimately, the case was removed to the Superior Court. During the pendency of that matter in the Superior Court, the unit owner passed away. However, her daughter and her heirs, through the estate, decided that they were going to continue to challenge the board's answer, which was, no, you can't have it. And if you do have it, it's going to be at your expense. It went through the whole, process. It ended up in the appeals court. And then the appeals court is the case that controls in our instance. And basically, the finding of the appeals court was that no, while the association may have to allow a unit owner to have a modification to the common areas, it is not going to be the association who has to bear the burden or the cost of making that modification. It is now going to be the unit owner who has to pay for that modification. And that actually tracks what the federal law always said. However, it doesn't track what we used to think Mass General Law 151B said. And again, the reason we used to think Mass General Law 151B said that in certain circumstances, the association would not only have to allow the modification to the common area, but also pay for it, was because of the interpretation of that particular law that the Massachusetts Commission Against Discrimination made in another case in 2010 called Kakovich v. Halcyon Hill Condominium. And essentially that case, and again, this is no longer the law, but I'm giving it you for background purposes. That case was a case that said, in that particular instance, a unit owner was told they could have the modification, but that they had to pay for it. The MCAD, then later on, she must have found out that, well, maybe I don't have to pay for it. Maybe the association does. So she put in a claim of discrimination in housing against the board with the MCAD. And the MCAD, it went all the way to the hearing, which that normally doesn't happen, because unless there's an actual hearing, they don't put out a finding. The finding in that particular case was not only does the owner have the right to have the modification, but under Mass General Law 151B, they determined that the owner of the common areas was the association, because the association basically controls the common area. So Mass General Law 151B talks about the owner or other person having the right of ownership shall be required to pay for the ramping of a front entrance of more than 5 steps, or for installing a wheelchair lift. So again, the MCAD always said, well, the owner is the association, so therefore the association is going to have to pay for it. The appeals court in the recent case in Gizzle basically said, no, unit owners own their unit and they jointly own the common areas. So since they're joint owners of the common area, if a unit owner or a resident or occupant of a unit needs a modification to the common area, yes, you may have to allow them to make the modification, but because they're the owner, they're going to have to pay for it. So this is a pretty big deal, because in prior practice, Matt and I would have to tell associations, hey, not only do you have to allow the wheelchair ramp to be installed, but now you have to pay for it. And I've had times where, as Matt said, the ramp had to be zigzagged or across the property because of the elevations. And in order to make the ramp useful to the person's front entrance to their unit, and that can be quite costly. I've seen things of $35,000 plus just to install these wheelchair ramps. So now, based on this case, it's going to track the federal law, which always said, hey, you might have to allow the unit owner to make an accommodation to, or a modification, I'm sorry, a modification to the common areas. But when you do, they got to pay for the modification. It's going to come out of their pocket. So again, it's a pretty exciting case, I think, for boards and property managers who deal with these modification requests. They're no longer going to have to factor in the cost, because while you may have to allow the unit owner or unit owner to make the modification of the common area, they got to pay for it. Next slide.
Yeah, and just wanted on the last note there too,
Sure.
and just add on to that, is that, you know, again, so if someone asked for these ramps now, the old thinking was that, well, the board had to pay for it. They don't, but the board still likely have to allow the resident to do it. But the board can impose, you know, some conditions on that approval, that the owner has to get, you know, obviously any relevant building permits, submit plans and specs, the work's done by licensed and insured contractors. So, you know, the board still has some oversight on that.
Absolutely. And they should, because it's still the common
Yeah.
area. And I should probably add, because we did have a question that came in earlier. Basically, you have to allow the modification if they qualify. They pay for the modification, but if the modification is put in an area, which is the common area, and the board is generally responsible for that particular area in terms of maintenance, then the board is going to have to maintain that particular modification. However, if the modification was given in a limited common area, and either the documents or pursuant to the statute, the unit owner always had to maintain that particular area, then they will also have to maintain the modification that they made and that they paid for. Okay, moving on to parking accommodations, because I don't think all boards are aware of this particular area. It's not as juicy as the assistance animal accommodations, but a disabled person, and typically this person will already have a handicap placard, right? And you'll know that they're handicapped. That's an open and obvious handicap if somebody has the handicap placard. Has come to the board and said, hey, you know, my parking space is just too far away from the front entrance, and I really need a space closer to the door. You know, give me an accommodation, find me a space. Well, that's something that the board does have to investigate. And there's 3 scenarios up there. Basically, to give you an example of when you might be able to say, well, there's nothing I can do, and when you might be, when you have to actually do something. So the first example, there's 100 spaces, 100 units, and spaces are already in the unit deeds as exclusive use and easement, meaning every unit owner already has in their unit deed a space numbered exactly where they're supposed to park, and each unit owner parks there on a daily basis. And then maybe there's some visitor spaces, but they're way, way, way far away from the building. In that particular instance, when the unit owner, I mean, a resident, and I want to preface something too, all of these accommodation requests and modification requests do not have to come from the unit owner. They can come from a tenant. They can come from an occupant of the unit, a family member, not the actual owner on the deed. They can come from a prospective tenant, somebody who's looking to possibly lease a unit in the condominium. They can come from a prospective buyer, somebody's looking to buy. They can even come from a guest, a regular guest of a resident who lives on property, but has a guest who has a handicap, and they visit and they want to be able to visit, but they can't visit because they need some kind of accommodation or modification to the property. So it's not limited to unit owners only. And when tenants make requests, this is an instance where as a board or a property manager, you actually have to deal with the tenant. You know, you might want to bring the unit owner in because it might be something that affects their, you know, unit or parking space, but essentially, it's the person requesting, the disabled person, that you have to have the interactive process with. You can't say, oh, no, you're going to have to tell your owner and then have your owner contact us. But in the first instance, probably obvious answer, nothing the board can do because there's, you know, they can't create a new space if there's no room. Every space has already been deeded out. The visitor parking space is away from the building. There are instances where I've had boards ask another resident if they would be willing to temporarily swap their deeded space because it was closer to the building, but we can't make them. Under the law, we cannot make them. This issue has gone before the MCAD, and they recognize that under the law, if a space is deeded, we can't make them give up their space. 100 spaces, 100 unit, parking is first come, first served basis, or spaces are assigned by the board. Again, in this particular instance, since the parking spaces are not deeded in the unit deed, then yes, the board has control, right? They have control over where people park to a certain extent. So in the first come, first served basis, you find a space that's closer to the entrance and you assign it to the requester if they're, you know, handicapped and they're entitled to the closer space. So now that you put up a sign, this space is assigned for this unit only. And as long as that disabled individual occupies the unit, that's their permanent space. Everybody else continues on the first come, first serve, but they don't park in the designated spot. If they're assigned by the board, then, you know, and so the board at some time and space said, you know, unit one's going to use space 1 and 2 and so forth and so on. This is an example. If it's not in the unit deed and the board assigned the spots, then the board must swap the spaces for that individual to get a space closer to the entrance. 105 spaces, 100 units, 5 guest parking spaces that are close to the entrance. Well, there you go. 5 guest parking spaces happen to be closer to the entrance, and this does happen. And in that particular example, then the board controls those guest parking spaces and could again assign the requester a guest parking space in exchange for the space that they're already using.
Yeah.
A really important point I want to point out too is if there are handicap parking spots already in existence at the building, and typically there are, you cannot say to the person, well, gee, the only spot we could ever assign you on a permanent basis would be one of the already existing handicap spots. And we don't want to do that because that wouldn't be fair to all the other handicap residents. Well, in that particular instance, the MCAD said it's a first come, first served basis. So if a handicap individual comes to you and says, hey, yeah, I sometimes park in the handicap spot because I got a handicap placard, but then sometimes I come home and it's not an available spot. Somebody else is using it. I need a dedicated spot closer to the entrance. If the only spot available is one of the 2 or 3 handicap spots, you have to give them one of the handicap spots in exchange for the deeded spot that they're, that came with their unit, that's in their unit deed. It's a temporary swap. It's not permanent. You will have to put a sign up, but you need to explain to them that, it's only for as long as they occupy the unit. It's a temporary thing. When they either move out, or if the unit's sold, if they're the owner that's disabled, then you can revert it back to a general handicap spot that's used by everybody. The new owner moving in doesn't have a disability, they get their deeded spot back. Did you want to say something more, Matt,
No,
about
no, I
it?
think you covered it there.
Okay. Well,
All right.
that's going to cover the next topic.
Yeah, so just two more kind of general or specific issues that we see come up a lot, and then we'll get to the questions. I see this quite a bit, so I'll try to do this fast here. Chemical sensitivity. I've actually seen more and more in these recently, and they usually come up one of two ways. You have a resident that says that they might be, have some sensitivity to chemicals used by the landscaping company, or sensitivity to perhaps cleaning products that maybe are used in the common area. So that's going to be more applicable, obviously, to a high-rise or mid-rise building where you have hallways and who the cleaning company comes once a week and whatever products they use, someone's sensitive to that. What does the board have to do if the resident comes along and says, well, I'm having a reaction, or I may have a reaction to these chemicals that are being used for the landscapers or the cleaning products. Again, like any other request, right? You treat it like any other request. Ask for the doctor's letter because the person's disability is not obvious. So have them provide a letter from the doctor and see what the doctor has to say. I think there's the publication I saw years ago from HUD, and I thought it was a good way to kind of boil this issue down, is that when it comes to the chemical sensitivity issue, if the person, either comes in contact with the odors or physical contact with it, are they reaching for, a box of tissues, or are they reaching for their phone to call 911? Because that's a big difference there, right? People have allergies to all sorts of things, dogs, odors, sensitivity levels. And sometimes it just, you get the sniffles, and after, an hour or two, whatever, once you're away from it, you're fine, and it doesn't really impact your life dramatically. Obviously, there are other people, though, who can have very severe reactions. Maybe they have underlying conditions like asthma or something, where they can go into, severe medical distress and actually have to call 911. Certainly for the latter situation, okay, the board probably needs to do something. For the former situation, maybe not so much. And this is a great example on the interactive process, right? Trying to delve down and get that information from the doctor into, what degree is this person sensitive? How bad will their reaction be? Particularly for like the lawn treatment where it's outside, they're not out there playing in the grass or anything, what's the really reaction going to be? And then if there is a situation where, they will have an adverse reaction, it's then again continuing that interactive process and also actually talking to your landscaper or your cleaning company and saying, okay, what products do you use? And because you can actually get the labels from those that have all of I can't remember the name of it now, but there's a specific name for when you get like the chemical composition, and you can give it to their resident and have their doctor, opine if there's specific, chemicals in these, and then talking to the cleaning company or the landscapers, hey, can you use this instead? And maybe they already have that in their, repertoire of cleaning or lawn treatment products, and it's not that big of a deal, and the cost won't change that much. So, those are really very fact specific, those types of situations. All right, the next one is request for assistance animals. Pam and I give seminars alone that last for an hour just on this topic. I'm going to try to do this in about 5 minutes. So, and I apologize, but because we talk about this so much, we didn't really want to talk about it a lot today. We wanted to focus on the case, that new court case. So, again, real quickly, a board or an association must allow both support animals and service animals. And in fact, the HUD and Department of Justice lump them into one category just called assistance animals. And that's specific to housing and airplanes. If you go to a grocery store, a restaurant, an office park, service animals, true service animals are only, allowed there. Those places don't have to allow the emotional support animals, but you as housing do. You can't restrict the breed or limit to certain weight. You can't say, well, someone wants to bring in their pit bull or their German Shepherd. as their assistance animal. You can't say, no, sorry, we won't allow that. Similarly, if someone, maybe your documents have a 15 or 20-pound weight limit for dogs, and someone wants to have a 40-pound dog, you can't say no in that situation either. And as far as the breeds go, again, the HUD guidance is very specific that you can't prohibit a breed just because of kind of generalizations and stereotypes about the breed that it might be dangerous. You can only prohibit that specific dog if you have specific knowledge that that dog has an aggressive, history in it, that it's bit people before or attacked people before. And on the weight limit issue too, I'll say on that is, telling someone that they can't have a 40-pound dog and they can only have a 20-pound dog. People get comfort from different types of animals, right? Some people like the little fluffy lap dog. Other people find more comfort in a big, lab or German Shepherd, and the board and the manager are not in a position to tell somebody what gives them that comfort. As for the type of animal, obviously it doesn't just have to be a dog. It could be a dog, a cat, a bird, fish, gerbil, rabbit, any typical household animal. If someone wants more of a unique animal, and these are actual requests that I've seen, I think Pam has too, a snake, an iguana, a small little pig. Those are all real requests that we've seen. If someone wants one of those, there is a higher level of scrutiny that you can put the resident through under the HUD regulations, and really, probe a little deeper with the doctor about why does it have to be a snake? What's so specific about this snake that a dog or a cat or some other typical household animal wouldn't suffice. If you do approve, you can impose reasonable rules that the animal obviously has to be on a leash or carried when it's in the common area, no excessive barking or other, disturbances. Obviously, you have to clean up after the dog when it does its business outside. One question I get a lot is, well, can we make the resident, walk the dog off the property to do its business? Or can we, ask them to go, over there behind the dumpster to do the business? The answer to those is both no, that you can't require them. You could request and ask them politely, hey, would you mind doing this? But you can't require it. And the reason for that is somewhat logical when you think about it. A, the dog doesn't know it has to hold it until it gets off the property or behind the dumpster. The dog's going to go when it's ready to go and do its business. Also, if it's, a thunderstorm or a snowstorm or 2 in the morning, and it's pitch black out, it's just unreasonable to ask somebody to walk, 100 yards behind the dumpster or off the property for the dog. You can't impose any type of pet fee or anything upon the resident for having the dog. However, if the dog causes damage, say it urinates on the carpet or something like that, you can charge those costs to clean or replace the carpet back to the owner. You can't require the resident to obtain any additional insurance related to the dog. The next one is a question we get a lot. Well, all of a sudden there's a dog here. We're going to get a million questions. Why does Mrs. Smith get to have the dog? Very simple answer that you should tell the residents. Pursuant to the applicable federal laws and regulations, federal and state laws and regulations, we had to grant a request for a reasonable accommodation. If they ask for more information, just say, hey, due to medical privacy laws, we can't really tell you anything else. The last 2 things here about online certifications and letters. This has become hugely popular, where you can go on these websites now, and for $29.99, you can basically buy this very official looking certificate that says, Fido is a certified emotional support animal or certified assistance animal. There's no such thing as a certified emotional support animal or certified assistance animal. These companies made it up. Good for them for making some money, but it's a total scam and racket. And that certificate alone is not sufficient. And HUD has specifically stated that. However, these websites, for an extra $10, you can not only get that certificate, but you can also get a letter from a supposed licensed therapist that says that I have treated, Pam Jonah, and I am certifying that she has, anxiety, and I'm prescribing this dog. And, we've seen a lot of those letters. And in fact, sometimes we know that, the letters from those websites because, it's the same letter from the same doctor. In fact, I've kept a file for this one therapist where I see a bunch of letters come from, and the letters are the word for word the same. They just change the name of the resident and the date on the letter. There is no case law that specifically says those letters are not sufficient, but I've spoken to, some folks from the MCAD as well as some folks from the Massachusetts Disability Law Center. And they all kind of actually agree with us a little bit, that says that, you know, when you get that letter, you're allowed to probe a little bit deeper and find out, you know, well, what methods were used? Because I know that there's some websites where you can get one of those letters by answering like 20 multiple choice questions, and you never actually even talk to a therapist. They just auto-generate the letter signed by the therapist. There's other websites where maybe you have, you know, a 1 hour long phone consultation with the therapist. And I think, in my opinion, that's a little bit questionable, which is why I think it's legitimate when you get those to push back and say, well, you know, what methods did you use to evaluate Pam's condition? How long have you been treating Pam? And depending on, you know, the answers to those questions, you know, you can decide whether or not you approve or deny their request.
Just one preface to that. HUD did say in their regulations, though, that they do recognize that there's telehealth, meaning people don't have to necessarily see a doctor in person. So just because the letter is from an out-of-state doctor doesn't deem it in and of itself not a good letter.
Yep. Okay. The next one is one that kind of related to this, is, you know, sort of competing disabilities. You know, a resident asks for a dog, and another resident comes out of the woodwork and says, well, I saw, you know, Pam's got the dog. I have a severe allergy or severe phobia of dogs. You know, the dog can't be here. Again, this kind of goes similar to the chemical sensitivity issue too. Well, to what extent is your allergy? You know, if you pass the dog in the hallway, you know, once a day or maybe once a week, you know, you're probably going to be okay. It's not like the dog's living in your unit. But again, you would ask that person who claims the allergy or claims the phobia, you know, to provide a doctor's letter on their condition as well. And ultimately, you engage with the interactive process to see if there's some way that the dog and the person with the allergy or the phobia can coexist. You know, if they don't live on the same floor, the dog's on the second floor, the person with the allergy or the phobia is on the fourth floor, and there's no reason for the dog or the resident really to ever be up on the fourth floor, well, then you tell the person with the dog, hey, you can have your dog, but you can't go on the fourth floor. And you say, well, you can't, you know, you have to use this exit when entering and exiting to minimize that interaction. And you see if there's some way for them to coexist. Ultimately, you could also go to court and ask the court for the answer and say, court, we're not in the position to decide, you know, whose disability trumps the other. You know, you tell us the answer to that question. And that's obviously, it can be expensive to do that, but at least it throws it into a neutral, you know, third party to make that determination. A couple of quick final ones, just some pitfalls to avoid. Discrimination, again, we've discussed these a lot. You know, don't just deny, engage in the interactive process, don't delay. You know, these are really kind of the key takeaways. Only ask for a documentation that you're permitted to under the law. When in doubt, consult with an attorney. It's a good advice for pretty much anything in your life.
I would just add, for the interactive process, I like it in everything in writing, because that way, if you do get sued at the MCAD, we can produce the writings, the exchanges showing that you had the interactive process.
And then finally, if you do find yourself, you know, before the MCAD, you know, what can happen? Well, the MCAD could, you know, impose injunctive relief, meaning that they would have to force you to allow the dog or allow the accommodation or modification. They can award damages to the resident, including out-of-pocket expenses, their legal fees, as well as, you know, emotional distress. You know, obviously you'd have your own legal fees. The MCAD also has the power to, you know, levy fines and sanctions, which can be anywhere from, you know, $10,000 to $25,000. So the risks here are very real if you are discriminated, which is why it's important to follow all the steps that we talked about.
And once you're in the MCAD, even if they settle, you are going to be required to take their classes of based on discrimination in housing.
Yep. All right, we're getting close to one. We'll go a little bit over here because we haven't gotten to any questions. I'm going to try to keep the questions, as there's over 30 questions as I look in the Q&A. We obviously don't have time to do 30 questions. So I'm going to try to keep the questions really to the ones that are more general in nature, that might benefit, you know, everybody on this, as opposed to, you know, there's some very specific questions in here that clearly, you know, a board or a property manager or maybe a resident is asking about a specific situation. For those, you know, you really should reach out to Pam, myself, or whomever your attorney is here at MEEB, and we can advise you on those. So the first question is a good one, Pam, on the court case. You know, do you think the Giesel case would have come out differently if the common area was not a limited common area, but rather was open to everyone? I have my thoughts, but you can go ahead.
Originally, we were focusing on the fact that that was a limited common area in the office, and some of us were saying, oh, this must only apply when it's a limited common area. However, if you read the case, it does say that statement that, you know, all unit owners jointly own the common areas. It doesn't say anything in that particular portion of the case that it's only limited to limited common areas. So no, I don't think so. I believe that the case stands for the proposition that
Yeah.
if it's a request for modification and the unit owner pays for it.
I agree. Can a condominium document provision enable the owners, the condo association, to recoup its legal fees from a successful defense of a suit for accommodation? I think unfortunately, no. Really, the only way you can ever recover legal fees from an owner is if they were incurred as due to some violation, whether it's non-payment of condo fees or some other violation of the document. And if you know, if an owner asks for an accommodation and you deny it, and you end up before the MCAD, unfortunately, and even if you win, unfortunately, you can't assess those legal fees back to an owner.
Right.
So there's a couple of questions in here kind of related to is that, you know, if someone puts in a modification, a wheelchair ramp, and then they, at their cost, and then they subsequently, you know, move out, can you, you know, require that they remove it? If so, at whose cost? Do you want to take that one, Pam?
Yeah, so now that we're operating, and even when prior to the case, we were always had the Federal Fair Housing Act versus the state law. The Federal Fair Housing Act says that, you know, while they are entitled to the modification and they have to pay for the modification, the maintenance depends on where the modification's made, and you cannot require that person, you cannot say, hey, yeah, you can have the modification, but before you leave, before you move out, you need to remove it at your expense. They basically say it stays there, but if the association finds that it's no longer needed for anybody, because, you know, you wouldn't take out a wheelchair ramp for a main entrance to a building if then another residence is going to need it anyway.
Right.
But the association can remove it at their expense.
Thanks, Pam. Next question is a good one that I do get from time to time. Can an association ask for recertification of the need for an assistance animal after some reasonable period of time, for example, every 2 years? You can, there's nothing that prohibits you from doing so. My advice to boards though is don't bother. And again, this is where, you know, a little common sense, think about it, is that, you know, a doctor has, a therapist or somebody has certified that Mr. Smith is disabled and needs this dog due to stress, depression, or whatever. There is no planet on which I can imagine that a year or 2 years later, if you ask them to provide a new letter, the doctor's going to provide a letter that says, oh yeah, Mr. Smith is fine. He doesn't need the dog anymore. And then Mr. Smith just drops the dog off at the pound. It's just not going to happen. And so I think you're wasting some resources and time on that. And that's, you know, generally my advice on that issue. So a couple of people asked us about whether or not the presentation, by the way, can be shared. Yes, after the presentation, I don't know if it's the same day, but usually within a day or two, we email out the PowerPoint as well as I think a link to the actual video itself, because this is recorded. I think we even post it on our website as well. Can the condo association make the pet owner carry the pet in the common area? Again, no, because if, you know, if it's a 50-pound German Shepherd, you know, it's a little difficult to carry. So you can force them to have it, you know, on a handheld leash. Because I've been told actually there's like electronic leashes now where the dog wears a collar and the person holds like a little clicker and it kind of gives the dog a shock if it goes too far. In my opinion, you're permitted to ask that it be on a handheld leash. I've even done some that say, you know, non-retractable. I know you've seen some people, you see those leashes that people have where it kind of retracts in and out and it can go up to maybe 30 feet. I think it should be, you know, no more than, I think 10 or 15 is usually a reasonable length. So the dog is very much under the control of the resident. But no, you can't force them to carry it because the dog could be quite large. Let's see, we just answered that question. This is a good one too. Are service animals or assistance animals allowed in common areas that people gather in, such as the gym or pool area?
Yes.
Yeah.
Anywhere
Yeah.
the resident who's disabled that has the assistance animal is permitted to go. their assistance animal has to be allowed there as well. With one exception, you could prohibit the assistance animal from being inside the pool, but they have to be allowed to be at the pool area.
Yep. This is a good one, if the, animal is creating disturbances, it's barking because, the owner is gone for the day and left the dog there, what action can be taken? The short answer is you treat it like any other violation that you in the document. If the dog barks because the owner comes home and excited to see the owner, or, the UPS or Amazon driver shows up and the dog barks for a few minutes, that's not a violation, right? Dogs bark, that's fine. But if the owner's gone for 8 hours and the dog barks incessantly, or it's 2 in the morning and the dog is barking, now it's a violation. And you treat it like any other violation. As I said, you would, the board or the manager, would send the the dog owner a warning letter saying, we've received these complaints. Per the rules that we sent you when we approved this request, the dog shall not create any, disturbances, nuisances. And, if this doesn't stop, you may be subject to fines. And then, that's really, then if it continues, then you fine them. And if it continues after that, you contact Pam and I, and, we get involved and send them a letter. But really, the answer is you treat it like any other violation. I think, Pam, you answered this one, but it's a good one. What if a condo owner wants to rent their unit and the renter has an assistance animal? Do we have to allow, rentals with comfort animals? This talks specifically about vacation rentals, presumably short term, but the answer is the same. You want to take that one?
Yeah, essentially, like I said, this law applies to anybody who's going to come on to the condominium complex. So if a unit owner rents their unit and the tenant shows up with an animal and it's a no pet community, and you send the letter saying, hey, by the way, landlord, your tenant has an animal, and then the tenant comes back and says, oh no, this is my assistance animal or my emotional support animal, and they go through the process of verifying that, then yes, you have to allow the assistance animal to live on property, even if it was for a short time.
Got a lot of questions about dogs, which I'm not surprised about. Can you impose additional cleaning costs on common areas directly associated with an emotional support animal on the owner of the animal? If you're talking about, the dog damaged the carpet by urinating on or doing something, then yes. If you're talking just generally because, maybe the dog sheds, the answer to that would be no, you can't impose those additional costs on them. Does a board, this is a good one because we do get this question from time to time. Does the board have to make accommodations for a person that's unable to shovel their car out because of a disability? Many places tow if you do not have snow cleared within a certain time after a storm. You want to take that one, Pam, or you want me to?
You can take it.
No.
I'm thinking exact. I mean, it would depend.
Yeah, I think the answer is no, because, it's not like, assuming, if the association doesn't have any on-site personnel, who's going to do it? The association's not going to hire somebody. And presumably that disabled resident could just as easily hire some high school kid or somebody come do it for them. So no, the association wouldn't have to, shovel someone's parking space.
Oh, yeah, that's, I'm sorry. I guess I didn't understand the question.
No problem. Let me see. A lot of these are very specific. Tenant request a handicap spot be created. Does it have to have the unit address or could it be a general handicap spot?
Well, a handicap spot that's general is open to any handicap resident. So if you just create a spot and put a handicap sign in and say, okay, you're all set, they're not all set because they could be away from the property and someone else could pull in with a handicap placard and legally you can't tell that person to leave. So no, when you're dedicating a spot to someone because they fit the criteria for that dedicated spot, then you put up a sign that says for the use of unit whatever number only. And then that person, and again, they exchange whatever other spot they used to have use of temporarily. There's a swap.
Gotcha. Who is responsible for a vehicle that parks in a designated handicap space dedicated to a particular unit? Who's responsible for the removal of that vehicle from the space?
It would be like any other space. At that point, it's their space. So they'd either have to range for, I mean, we wouldn't be moving it.
Well, no, but I think if someone parked, if the association granted someone a dedicated parking space and said this space is reserved for Pam and it's very close, and so it's your dedicated space and it's close to the building, and somebody else parks in it, the association enforces the
Yeah,
document.
if they park in it, yeah, then, yeah.
Yeah, the association would be, the responsible for, towing that vehicle if need be. And you could even put up a sign, violators, may be towed, et cetera.
I was thinking for moving for purposes of snow removal.
Oh, no, I think it was just someone parks in their spot.
Gotcha.
Let's see here. I'll take maybe one or two more questions. If a property owner has rules about when construction can occur on the property, does the board have to allow the modification construction anytime? Or does the owner need to abide by the rules? My guess is, because I know this property manager does a lot of properties on the Cape, and I know a lot of properties on the Cape, for example, state that you can't do any construction Memorial Day to Labor Day, because that's when most people are there, and obviously they don't want to disrupt their vacation. So my guess is that's what the question is about. Unfortunately, I think if someone, came along in June and said, hey, I need this wheelchair ramp, or I need whatever this is, it's not like their disability can wait until after Labor Day. So unfortunately, you probably would have to, allow that construction to take place at any time of that year.
So that would be an accommodation and a modification request in one.
There you go. Let's see, maybe take one more question. This is a good one, I think, on parking. A handicap spot was assigned to a qualified owner. In exchange, their assigned parking space was surrendered to the association, which has rented it to another resident. By all parties agreed in writing, should the association be getting rental income of another owner's spot? I'd say if you agree to it in writing, I don't have a problem with that, because presumably you could have gotten rental income from the other spot anyway. So I think that's fine, is that the other party agreed to it specifically.
I think if they agreed to it, but if they didn't, then you shouldn't be renting that swap spot, because the situation could occur where they sell and now they need their spot back. So, yeah.
One thing I forgot to mention, I thought it was in my notes, but I didn't, but just another example, and I think Pam touched upon it, about a modification, and may as well be our last point here. A common request for modifications I've seen is for someone to install like a stair lift or chair lift. Maybe they live up on the second floor, it's only, maybe 2 or 3 stories, so there's no elevator or anything in the building. And again, the person, and maybe they've lived there for years, and all of a sudden they develop some disability, difficulty in stairs, and they want one of those ride-on stair lifts. Does the board have to allow it? Again, you go through all the same, steps. You also, again, it would be at their cost under this case, but there's an added level that you should look at in this issue. And that is that under building codes, stairs must be a certain width. I can't remember the exact number of inches off the top of my head, but it's something like 30 or 36. They have to be at least 30 or 36 inches wide. Obviously, if you put a ride-on stair lift on the side of it, that's going to cut into the width of the stairwell, and may make your stairwell out of code. So one of the things I always do with those requests is that I ask, I tell the property manager, or now maybe even the owner, actually, I usually tell the owner, hey, go to the building commissioner, building inspector of your city or town, and have them give an opinion that the lift will not violate the building code. And if you get that opinion, then it's fine. But if the building inspector comes back and says, well, yeah, this lift will violate the code because the stairs will be too narrow, well, then case closed, and you could deny the request. And that goes to, one of the things I talked about the lift not being, physically possible to install.
Any modification has to meet code, basically.
Yeah. I think most of these questions are either very specific or ones we've already talked about, and we're at a little over our time. So Pam, I don't know if you have anything else you wanted to.
No, I feel like we covered it, but anybody who wants to reach out to Matt or I, feel free.
Yeah. Thank you, everyone, for coming. We hope you enjoyed it. And as I said, the slides and link for this will be emailed out within the next day or so. Thank
Thanks,
you.
everyone. Have a good
Bye.
day.